look, I mean, there are lots of things that went into Donald Trump's executive orders and his false statements about South Africa, which have led him to act the way that he has, and whether he genuinely intends it or whether it's in the first stage of his beloved bargaining process, negotiation process, and what he wants from South Africa to drop the ICJ case. We simply don't know. He is probably even to himself impenetrable. But there is the Expropriation Act. It is now, as a result of the DA's legal papers, going to make its way through the court system, starting in the High Court, almost certainly then to the SCA and to the Constitutional Court. Advocate Tembeka Ngcukaitobi is somebody who is active in the courts, but he's also a legal scholar with a particular interest in land reform, and I'm delighted that he is able to spend some time with us this afternoon. Tembeka, good afternoon.
Good afternoon, and thank you for the invitation.
Can we not discuss whether redress is necessary? Can we assume, for the sake of our discussion, even I know that some listeners might balk at this, that redress when it comes to all sorts of things, including land, is absolutely necessary, and concentrate on the, to me, more crisp issues of why we haven't done better than we have already, and to what extent the Expropriation Act in its current form will contribute to an improvement in this necessary redress?
Thank you. That's actually a very helpful way of framing the debate. It's amazing how many people question that premise, but I'm glad in this conversation we are not. So, two questions. Why have we not done better than we should have? I think the explanation is clear, even though it's disputed. Number one, we should have passed a law in 1994 already, or at least 1996 when the final constitution was passed, to enable the state to redistribute land on an equitable basis. There is an injunction in the constitution that requires the state to do that. The state has never passed it, and it has no explanation why it didn't pass it. In fact, the ANC, in its conference of 2022, resolved to pass a land redistribution bill, which would at the very least enable the state to redistribute land in its own hands. The state has a lot of land. It can resettle large numbers of communities. It can generate income for those communities. It could start large-scale agricultural projects in those properties, but it never did. Its priorities were elsewhere. Secondly, the land reform program has been hobbled by huge inefficiencies. The last land claim process was opened up by Jacob Zuma, but before then, the first land claim process closed in 1998. It's astonishing, but it's true, that those land claims lodged in 1998 have not been settled. We have 5,700 of them that have not been resolved. That is an astonishing level of neglect and inefficiency in the system. Thirdly, like everything in South Africa, the problem with land reform is beset by corruption. In 2013, and I wrote about this in my book, Land Matters, the SIU published a report in which it said, in every 4 land claims, at least one has a corrupt element, where the claimants are putting dubious claims, the owners are asking for astronomical and corrupt amounts, and the state officials are part of either the claimants or the landowners. Now, a combination of these three is toxic, and it has resulted to where we are. Now, second question, what can we hope under this bill? I'm afraid I've tried to be as positive about this bill as I can because of the premise of your question. But I think that the problem is that we are putting too much into this bill. This is not a bill for land reform. It is a bill for expropriation of property so that it can be owned by the state, and the state can make use of it for its own purposes. This is why this bill is located in the Department of Public Works, not in the Department of Land Reform. So it is a useful start, but it is by no means a sufficient end.
The fears that it is creating, the anxieties, the sense that good law protects citizens from bad actors, and a law which might seem to be necessary and which might seem on the face of it to be benign, which can be used for ill in the hands of people who want to do ill, is not a good law. So there's the sense that, yes, no mass confiscations of productive agricultural land are being taken away from white farmers, many of whom are Afrikaans speaking at the moment. But what about the future? Look to the north of us. Do we need a bill that is clearer about the conditions under which expropriation with nil compensation is a reasonable result?
Now, I agree with you that we don't want a law that permits arbitrary action. We don't need to look at Zimbabwe. We can look at South Africa about the devastation that apartheid caused, because the powers that were given to the state president and the powers that were given to basically an illegitimate regime were vast. And look at the hardship that the apartheid government visited on Africans. So we don't want to go back there. But what about this law? Firstly, this law is constrained by the rule of law. In fact, I always say that this is one of the strengths of the Expropriation Act. The expropriation procedure is two stages. One is the expropriation proper, which is when you are trying to seize the land. Let's use that language, even though it's improper. But to be extreme and to illustrate the point, the state is attempting to seize the land. The act of seizure of the land is an administrative action. It is therefore subject to administrative review in our courts. So there is not a single piece of ground that can ever be taken without judicial intervention. Secondly, the determination of compensation. So where the state has decided, I want to take your land without compensation. The compensation part under the Constitution can only be decided by a judge or by agreement. So you as a landowner either agree with the state on an amount. If you don't agree with the state on an amount, a judge decides whether or not the amount offered by the state is a fair and reasonable amount. So at the heart of it, if you remove the heat for a moment, at the heart of it is a judicial-led process. Some of us have argued that it is wrong to insert the judiciary into land reform because it's going to lead into inefficiencies that are inherent in the court system. And the third point is that this is a highly procedural law. You know, I counted 17 steps between the time the state intends to expropriate and the time the property is finally in the hands of the state. 17. In addition to those 17 steps, there are the legal steps of the court process. I don't know how many those are, and they could double that number. So it's actually going to lead into a very inefficient method of acquisition of property. But it is a highly protective law for property owners.
Then, if and I take your point, there do seem to be some members of the ANC, at least, that think that the Expropriation Act is a land reform act, and I think you've explained to us very cleanly that it is not. But you've also explained why land reform has not happened the way that it morally, legally, constitutionally should have happened. So, what are the key things to start getting that right?
Well, under this act, there is the section that is contentious, section 12, subsection 3. So
that is the public purpose, the public interest, yeah.
Yes, precisely. So let's unpack that a little bit. So firstly, it's a compensation provision, which means only a judge can decide the compensation. Secondly, it's restricted to public interest. So in other words, the state cannot even attempt to seize property for public purposes. And thirdly, it's restricted to land. And land is not defined in the Act, but generally speaking, it tends to refer to agricultural land. When you look at land parcels in the Act, it's referring to surveyed land, whether it's registered in the deeds office or not registered. So by definition, it's a very restrictive usage of that power. And then secondly, it's a discretionary power vested on the judges. where they think it is just and equitable. In other words, it does not mean just because you hold land on a speculative basis, it will automatically be taken without compensation. It is simply a factor that may be taken into account. So every piece of ground will be subjected to this requirement of just and equitable. So that's on the Act. What do we need for the land reform that we have been promised, but it was never delivered? We must think about what we need now. What we need now is to settle the 5,700 land claims that are sitting in the government offices. That's what we need right now. Mm-hmm. Once we have done that, what we then need is to pass the Land Redistribution Bill, in which we will explain who needs land for what, and who must get priority and why, and what is the right of redress for those who will lose out. And until we answer those questions, we are going to have a conversation that is disjointed, because the people speaking and those listening are not saying the same thing.
I found that incredibly helpful, and I'm sure most of my listeners, those that are prepared to open their minds and listen, will have done so too. Thank you very, very much indeed, Advocate Tembeka Ngcukaitobi.